Canada board. Yeah. So.
Okay, so like you and I had discussed on the phone, the purpose of this meeting is to try to answer your questions about our decision making in the process, and according to the questions that you asked in your email and what we talked about on the phone. So Erin Lee is the supervisor of Leslie.
Okay.
So she can speak to the things that happened with her and Leslie, but she may not be able to answer some of the specifics about what happened after that. I have reviewed the file, so I'll do my best to answer where I can, and then we'll figure out what the next steps are going to be.
Okay.
Okay.
Sounds fair.
All right. Is there anything else you were hoping for or expecting out of this meeting?
No, that's about it.
Okay.
I have a lot of questions.
All right.
I want answers to.
Okay. Do you want to just start with your questions?
Sure. So,
Oh, and I guess I should say, for me anyway, and I'll let Erin Lee speak for herself, I'm not consenting to being taped.
sorry about the notepad.
Okay?
Yeah, me neither. Thanks.
Gotcha. Yeah, no, kind of figured that.
And I'm not taping you, just to be clear. Well, no,
that is fair.
The phone is there just purely in case my workers are trying to get me.
Gotcha. Okay, so my question, I guess, for you would be, is how much of the case do you know specifically? Have you seen the video?
I have not watched the videos recently, but I did see the videos when they came out.
Okay.
Yes. So I did see 2 videos.
Okay. You saw
I saw
the first one?
Yes.
Where they're in the house and...
Yes. I haven't looked at it recently, like I said. So we're going back to...
Summertime.
Well, April. I think the file opened April 27th.
That's right.
And Leslie was there within a couple of days. I want to say the 29th.
The 29th.
Okay. So yes, I saw the video from that day for sure, and I believe I saw the one from May the 1st as well.
Okay.
Yes. And well, go ahead. That's me.
Okay, so first question, do you condone Leslie threatening child apprehension in the way that she did in the video?
I guess I see it differently, to be perfectly honest with you. I can understand why you might feel that way, but I think for us, it's more a question of wanting to be really transparent and honest with people about potential recourse. If people aren't cooperating with our investigation. And I know that CAS, intervention can feel, and people can experience it as extremely intrusive. So I get that, and so I can understand that it might be a perceived sort of threat. I don't see that she was threatening to take your children so much as just trying to outline whether she was able to articulate that in the best way. I don't feel that she was inappropriate. I feel that she was trying to just be transparent about what could potentially happen. To be honest with you,
okay.
Not to say, this is what's going to happen.
Okay.
Because what I read in the file too, and I don't remember if these exact words were in the video, I assume they were, she said, "I don't have grounds to take your children today."
Yeah, she said that after waiting outside my house for an hour and, coming back and demanded entry again.
Mm-hmm.
I think, if I recall correctly, I think that it seemed, and I didn't see your face on the video, on the first one anyway, so I couldn't obviously read your nonverbals. I could just hear your voice, so correct me if I'm wrong, and that's sometimes the danger of videos too, right, is you get a bit of a contextual piece if you see nonverbals. But I think you were a bit anxious about Leslie taking the kids and
was terrified.
Right, fair enough. And
terrified.
Right. And I certainly know that was not at all our intent going in there, and I know it wasn't Leslie's intent going in there at all. It never is. And I've known Leslie a long time, since she's been at the agency, and I mean, certainly being videotaped was very disconcerting for her, as it would be for many workers. So was her were her words, like I said, perfect? You know what I mean? In that we all say things sometimes. We're trying to get something out. I mean, I'm doing it right now, probably. We're trying to get a point across, and it's not coming out the way we really are intending it to. But I do know that she was trying to, certainly when you were looking for asking the questions repeatedly, she was trying to give you some reassurance that I'm not apprehending your children today, but to stress that, if we have concerns about something and we aren't able to get the information that we need, one of our courses of action, that's the most intrusive thing we can do. And it's a possibility. We can't ever say to a family when we're in a child protection investigation that will never happen, no matter whose family it is. So I think that the goal or the intent was to just be transparent about the possible sort of courses of action.
Okay.
If that makes sense.
Yeah, it does. So another question I have is, why were the police there after finding out? Leslie had said that the police were there because there was a sexual abuse allegation, but she had attended the school and interviewed the children and ruled out sexual abuse. So my question is, why did she bring police?
Well, we often do. We reviewed some of your history. The police who called us about the concern. We know that there's been some domestic violence referrals in the past. And so that is not uncommon to bring police with us for worker safety concerns. Sometimes the police will encourage it. Did they encourage to come this time?
What I read in your investigation
but
plan was that the plan was call the police, let them know we were going, that Leslie was going, and then let police decide whether they came or not.
Okay.
So
Okay.
I assume they decided we will come with you.
Right.
So why would a decision like that be left up to police? I mean, police aren't social workers. I mean, they can't.
But they do know, they have information on families, and I think that given that there was, to be blunt with you, some lack of cooperation, they were somewhat worried about
But there was only no
worker
cooperation because the police were there. And I mean, in between the domestic assault and this particular complaint, I mean, we had 2 CAS visits for complaints, and no file was open, it was closed. I mean, the police weren't brought in those previous 2 visits.
I guess I don't really know how to answer that. Like, I think that sometimes when we're concerned about, I know that Leslie was a little bit concerned about her safety. Certainly, like I say, the videoing was disconcerting, and I think certainly the police, had information that they were saying, if you want us there, we can be there and perhaps should be there.
More in a to keep the peace.
Yeah, absolutely.
Okay.
Kind of role.
But if they weren't there, I mean, it wouldn't have happened the way it happened if police hadn't been there. Bringing the police, to me, I mean, I interpreted that as kind of a show of force. It's intimidation to me.
Mm-hmm.
I think I hear you, and I think I understand where you're coming from, and I know I read about the conversation you had with Mary Beth at the end of your involvement, where she was kind of saying, for the future, what would make this have gone better or gone smoother? And what I read in there was that the police coming right at the beginning was what was really hard for you. So I think that is, I'm really glad that's there on the file for the future, so we can, if we do have to knock on your door again, we can take that into consideration and and understand that. And it would, I see so much potential in this, what happened in your case and in this situation, to have gone much more smoothly. I think we both want the same thing, sort of not to have to get into a 5-month court battle or whatever, over getting doctor information and getting your house cleaned up, which you did right away. So I think we both want the same thing out of this. We don't do things perfectly, and we have to make our best guesses about how to do our investigations the right way and what the right approach to take.
And is it fair to say, Kim, too, that at a time where we were really focusing or trying to refocus our practice on the 0 to 5 population. Is that fair to
And yes,
talk to
and
Kelly about?
absolutely.
Yeah.
Kelly's researched our standards.
Yeah.
I know a lot.
Yeah.
We have in the past we haven't paid as much attention to standards as we're paying to them now.
When did that start?
Early 2014.
Okay.
We realized that we had missed some serious cases and had some opportunities to help kids that where we could have helped kids more if we had more quickly, if we had followed the standards more, and also done so I would say to you 5 years ago, you may have had a very different response from us. We may not have, might have accepted your refusal to not have us see the upstairs or see your kids privately, and we might have just walked away there. What we learned in some of the things that happened to other kids was when we do that, we take the risk that there are kids out there being hurt that we're not seeing. So we are trying to follow the rules more closely. Even though there might be signs that, okay, it feels in my gut like everything's okay, but I really better check this out just in case I'm missing something. That's the way we're trying to behave now.
Okay. Fair enough.
And trying to really stay within our timelines, our 30-day timelines. And if we don't have what we need to complete an investigation and the kids are little and therefore more vulnerable, then yes, I think in your situation, you saw us get intrusive quickly. You know what I mean? In order to try to get those consents that we wanted and to get that collateral information, we did get intrusive quickly. Now, I know from a decision-making perspective that my hope at the time, and the file only stayed with me, as you would know, for a very short period of time, but my hope was that we would do some sort of concurrent planning. I knew I absolutely endorsed pursuing an application to try and sort of continue to work with you and to get the information we wanted, but I also at the same time endorsed, let's get an order for records, pursue an order for records at the same time, and was hoping that, we wouldn't have to be all the way down the line with a supervision order. So sometimes we have to sort of take those steps. It allows a client to be eligible to then get, have a lawyer and get some legal advice. It just puts things before another sort of impartial third party, like a judge. But my hope at the time was that this wouldn't actually go all the way, that we wouldn't actually need to have a final supervision order for 12 months or whatever. I don't even remember what the application was at the time. That my hope was that we would be in a position where we would ultimately work voluntarily with you. But I was feeling that we were kind of at a crossroads, to be perfectly honest with you.
Okay, fair enough. Okay, so another question I had is why wouldn't Leslie communicate via email?
That's an internal policy that we have. I think I did break the rules on that ultimately, and we sent consents to you.
Yes, you did.
Yeah, I did. And I could have actually had my hands up for doing that. But
even with my concern, you emailed me back. We emailed to arrange this meeting here today.
So we're not supposed to. We're not supposed to email with clients because it's not guaranteed to be secure from a privacy perspective. So
maybe there's voicemail. Really.
So I email about things that are non-identifying and not private information. So my emails are carefully worded not to really have names in them, and I also make sure there's no email string on them. So you sent a long email with your concerns about what happened in your case, which has your private information in it. That email it wasn't secure, like it goes over or not as secure as we want our information to be, so I was careful not to have that attached to my email back to you. Okay. Just so that it didn't live out there in internet land in another forum that somebody could access.
I can appreciate that that's frustrating, I think, in the world of where everyone communicates electronically.
With AODA coming out and compliance to that coming out, not everyone can use a phone, and like not just for hearing impairments, social anxiety. You could have a phonophobia for all you know. I mean,
I hear you. I do.
So if I'm requesting communication via email and I don't have to identify what kind of disability I have, I mean.
Yeah, it's something that we need to
We're
probably
going to have to
wrestle
look
with.
at that
And
on
if you brought
an
it up,
individual basis.
Yeah. Because I think I did say to Leslie, that is against our policy, but I don't want to slow this down anymore, so go ahead and email the consents.
Okay.
But it is typically something that we're not doing.
Okay.
The other, so there's the privacy reason, and then there's also the social work benefit of having a dialogue with somebody where you can, rather than the back and forth of email, or texting, where you don't necessarily have the ability to talk face to face with someone and have all those nuances of body language and context and immediate clarification of, well, what did you mean by that? But I mean, I understand that's one small reason. It may not be a good reason, but
okay, because I know a lot of like I run a support group for people who've been in my situation, and it's for parents dealing with child protection agency, it's scary even just to call.
Yes.
Right.
So
Yes,
by using the email, that would enable them to get what they wanted to say out. I just think it would be and ultimately would be in the children's best interest for that parent to be able to have a way that isn't as scary to submit whatever, arrange appointments, or in my case offer documentation like doctor's notes and all like that.
okay, well, like Erin, you
Yeah.
said, it
Yeah.
is something we're wrestling with. Social media, the whole gamut, is something we're really wrestling with and trying to figure out what the right thing to do is. So that's certainly part of my role here, so I will consider that. Appreciate your feedback.
Yeah, like I get the privacy thing, but with social media too, especially, it just would open a whole lot more opportunities. And I think going back to the strategic aspiration of being a trusted agency, a real social media presence, and I think that would help that.
Mm-hmm.
I don't think that it's a good idea to use email to resolve conflicts, though. That would be my only caveat. There's kind of the people.
If the client wants it, though, if the client requests it.
Yeah, I don't think that. I mean, it's kind of like, when you read books about managing your email and using email effectively, there's sort of that rule of thumb, like, you should never send an email when you're mad, right? Because the tone always comes, and in your personal life even, right?
Absolutely.
Where you're like, I don't like what they said, and you want to just write back, right? And it's like, oh, you should never send it, because that doesn't really resolve conflict. It almost perpetuates it sometimes. So I'm not suggesting that there isn't a role, or that there are times when it might be appropriate. It would just be one where, as a manager, I'd be just wanting to be careful about.
Yeah. Maybe be case by case.
Yeah. Mm-hmm. Yeah. Absolutely. Yeah.
Okay. Okay. So do you agree that Leslie's sworn affidavit doesn't match the video?
No, I don't think I do. But again, I haven't watched the video recently.
I do have the video here, and I have also her sworn affidavit here.
Yeah, I have her affidavit too.
And
so, and this is your feeling that she knowingly lied when she swore that you asked asked whether your children would be taken, or asked.
No,
I remember the wording.
Didn't ask her anything at the time. I was telling her to leave my house.
Okay, but you said you were terrified that your kids were going to be taken away.
Yeah.
So I'm wondering if Leslie understood that somehow, either by something you said or did, and then she instinctively wanted to reassure you about that.
But she didn't reassure me. She threatened to take the kids.
And I have a different interpretation of that. She said, I'm not apprehending your children today.
She said that in the
reassuring.
second video, but when she first comes into the house, she asked to see the kids. Okay. She asked to see the upstairs, and I told her, no. You said legal consult, all that. Please leave. I say 3 times, please leave. Then the officer says, there could be further repercussions. And then Leslie adds, in terms of the kids staying here. I was not asking her a single question at all. And she said that I had asked to know what would happen if I refused. And she says that she then explained that the agency would prefer to work cooperatively. However, if they refuse to allow me to see the rest of the home and the children, it could have an impact on our level of involvement. I explained that this could result in a court application and ultimately could impact on where the children reside. It's not how it happened at all. It matches her case notes, but that's not what happened. It doesn't match the video at all. You both saw the video. Would you agree with that?
I understand the words don't match the words on the video. I think the intent matches it. And I'm quite, like I told you, quite satisfied that Leslie acted very appropriately in that video.
Well, no, but that's not my question. My question is, does the video match this? I mean, in the video, I didn't ask any questions. I told her 3 times to leave, and then she told me that there could be repercussions on where the children reside. I did not ask to know what happened. I didn't ask any questions. I was telling her to leave.
So is it a matter of the sequence of her recalling the event?
Well, it's not even the sequence. I never asked her once what the possible outcomes to not cooperating were. I don't ask any questions.
Because I guess for me, I'm interpreting sort of maybe it's the second video, but either way where you're asking her, are you going to take my children? What's going to happen next? She's saying, no, I'm not going to take the children today. I'll come back or whatever.
And that's described later on in the affidavit, but I mean right here, that's an outright lie. That didn't happen. And so she acknowledged seeing the video as well, so I mean she knows the video says that it didn't happen that way at all, and she lied and swore an affidavit. Anyways,
so I don't see that as a lie at all. I see an affidavit is not intended to be a verbatim account of what happened. It should embody the spirit of what happened and the intent of what happened.
It shouldn't be misleading, and to me this is very misleading. I mean, you guys got a motion against me based on this, on a prima facie basis. This hurt me. And she lied. It's misleading.
I don't believe she lied.
It's extremely misleading.
So how do you feel that statement hurt you? Why does it hurt you to say that you asked if your kids would be taken away?
Well, it's a criminal offense to lie in an affidavit.
No, but you said that statement hurt you.
Well, what she actually said hurt me. I'm going to take your kids. She threatened child apprehension after I told her to leave my house. When someone asks you to leave your house, you don't say, well, we could take your kids.
Yeah, you do. We do.
You do?
Let you know what could happen.
Even if someone doesn't ask. Even if someone doesn't ask.
Absolutely. So that's why the question, whether you asked or not, is irrelevant to me. Okay. Because you have a right to know that information. And you may not have asked it. And even if you didn't, I would still expect Leslie to tell you what the possible repercussions.
But, I mean, ultimately, she didn't see the upstairs. She didn't take my kids. So, I mean, the threat wasn't even a real threat. Or it wasn't a real outcome to what
but still possible.
Absolutely. And she did call me, I think she left the home to talk to me to sort of say, this is what I'm getting, this is what the situation is, what are my next steps. And I mean, at that point, like, I think she went back to you and you guys had another conversation, and she even offered to go in with, because you did express, with the police being there, that was an issue, and Leslie offered to just leave the police outside and go in and go upstairs, and I think you paused and then still refused to allow her to go in.
Yeah.
So, I mean, every situation is a little bit different, and a worker going in can sometimes, think needs to be transparent that could possibly happen, and then they sort of step out, try to synthesize all the information in their head, in their minds, and then also on the phone with their manager, and decide and I had to sort of think and talk with Leslie through do I have enough information at this moment to think that these kids are at immediate risk of harm where we need to remove them. I asked that question out loud to myself even. I didn't feel like it had quite tipped that threshold yet, because I know that we don't want to remove kids. I mean, it's got to be to a level where they absolutely have to be removed, and we wanted to work with you, right? So it was a discussion in my mind that I was sort of having in my own mind and with Leslie, and said, okay, we'll get at the end of it all, we'll go back Friday. We'll be there as you guys had agreed. We'll be there Friday. We won't remove today, but we'll be there Friday. But was it a possibility? Yeah, I think it was, and I think it was fair for Leslie to say that.
And I get it. That's scary and that hurts. But I've experienced it the opposite way. 30 years ago, when I started as an intake worker, I wouldn't have said that to people right from the beginning. I would have been afraid to say that. And then when I turn around and there are serious concerns, and I have had to apprehend kids, I've had parents say to me, "Why didn't you tell me?" They feel betrayed. Because I hadn't been that open about the level of authority that I had and what could happen. And you, as a worker, you want to reassure people and say, "Don't worry, just let me in. It'll be okay." No, I know, but again, that's a mistake that we've made in the past that we've learned from. Erin Lee said it earlier today. We can never promise that we won't be removing kids, even if at the time we're thinking, this isn't a case I'm going to be apprehending kids. There's nothing that serious here. If we said that to you and then we did find something serious, it would be way worse to have sort of made you that promise and then betrayed it. So that's why we try to be really transparent, really acknowledge the authority that we have and the possibilities that people might face. If it comes to it. So it's tough. It's really tough.
No, and I do have a lot of respect for the mandate of the agency. I do. That's why I'm here. I want to see where the problems are, and I want to try to
more
fix
clients
it.
were like you in some ways in terms of working with us and advocating. I mean, it's absolutely to be commended. We may not agree on everything here today, but I think we can at least agree that we want to move in the right direction, right? As a community.
Absolutely.
Yeah, absolutely.
Yeah.
And I know that your background is also in human services, or you've done some studies in human services of some sort, right?
Yeah, the social service worker.
Yeah.
I'm also registered with the college.
Yeah, I thought so, yeah.
Okay, so you guys agree then that Leslie's intent in the affidavit matches the video. Is that fair?
Yes.
Okay. Okay, so another big question I have is the response time to when I had inquired to know about information. I had requested on May 1st on video to know what the concerns were and what the basis for those concerns were so I could address them appropriately. It took 41 days to get that information. I would like to know why it took that long.
So let's just be clear on what did you get on 41 days? Is that the letter with the reasons for service?
Yes.
Let me just...
it was the letter, it was the second letter, Marion Ratzinger.
Or you're not talking about your file disclosure here, or are you?
I had requested file disclosure and stuff like that. But
this is probably where I know Leslie was gone fairly quickly into May, so I think
so probably the gap. We had a couple worker gaps here,
absolutely.
Right? We had Leslie leave unexpectedly, and we had Marion leave in a planned way, but still, yeah, things
left a gap. Yep.
do fall through the cracks when we have worker changes.
41 days to get that information, and
So 41 days to get what exactly?
Mhm.
Was it the letter?
the concerns and the basis for them, which she eventually sent me on June 10th.
Who was that? Who had sent you that?
Marion.
Marion? Okay. Just a second here, because I know I printed off some.
Yeah, and I think that was about was that one of your first visits with Marion?
No, she just, I guess it would have been the second. She hand-delivered
Okay.
one letter, and then she hand-delivered this letter as well.
Mm.
I made a note of that, but I remember seeing in the notes that you got, Marion gave you a letter about the reasons for service, and I was just curious about what that was, or whether it was
Reasons
part
for
of
serving me?
the reasons.
The concerns.
The
reasons for our involvement.
The reasons
essentially,
for
right?
service
Gotcha.
being, yes, yeah.
Gotcha.
That's the way it was worded in the case note, but okay. So, honestly, I agree with you, that is a long time.
Yeah,
Absolutely.
and I mean, you want to adhere to standards and all like that, and you want to work cooperatively with people. I mean, I tried for 2 months to work cooperatively, and upwards of 10 days sometimes to respond to voicemails and stuff. 41 days to get the information I was asking for.
And you asked specifically to get them in writing?
Yes, absolutely.
What date did you receive the letter again, Kelly?
June 10th.
So we had an internal consult June the 5th where there was direction provided to Marion to provide a letter outlining, this is illegal, so this would be privileged and client solicitor privilege, where Marion would provide a letter outlining the details of our concern. That doesn't mean that that's when you requested it, but that's sort of when it was.
A worker got specific direction to do that. That doesn't mean it shouldn't have happened earlier. Especially if it would have been helpful for you to have something in writing to look at, to talk to
Just seems like
with
I
a lawyer about.
kind of got penalized because you didn't meet the investigation went past 60 days. And I don't feel like that was entirely my fault. And I feel like ultimately it was me and then my children who paid for it. I don't think that's right.
Well, let's talk about that, because I think there's probably things on both sides that could have been done differently. I don't know if you're willing to
absolutely.
or if you're open to that.
Yeah.
Like, our main thing was wanting to see that your house was cleaned up, and then wanting some kind of medical professional to reassure us that your kids' needs were being met.
Yeah, and this was documentation I had sent on June 19th.
We asked for consents for a number of providers.
Yes.
School, the lawyer was one to communicate.
And I
Family
offered
doctor for all children.
an alternative
for an
that
ABI program.
I could get all that information very easily. And I tried, again, for that 2 months to try to give you guys these documents.
I don't see any evidence of that.
I can show you my email. Just give me a second.
Because we would have, it might not have satisfied us, but I don't know why we would not have taken it.
Stack load of stuff here.
Right, like, so one of our worries, honestly, is if information comes from parents, then they might be withholding something that they don't want us to see.
This is
But
where I
usually-
addressed on the 19th. And then she responded to that one 10 days later, offering to meet in office so I could show her all this documentation. And before I could even call her back, you guys brought me to court. And this was sworn in my responding materials in court.
Who was that? To Mary.
This was, and I remember reading this, but I don't see any, you're saying we can bring, okay,
Anything
fine.
she wanted to see.
And I'm just saying, why didn't you? Because we were asking for this. So I can't imagine, I don't see anywhere where she said, no, that's not acceptable.
No, but that's the thing. She didn't respond to that at all for 10 days.
I did see that.
And then she left me a voicemail, finally offering to
Mm-hmm.
meet in office, which I had been asking for a long time,
Mm-hmm.
so I can bring this stuff. And before I could even respond to her, 2 business days later, you guys brought it to court. So I didn't even get a chance to
So that
bring this
office
in.
visit never happened?
No.
And I think...
She responded to this on June 29th. July 2nd, they signed and swore
Mhm.
everything.
See, and I have to verify this. I think our records show that you didn't show up to that office appointment.
Oh, I have.
Or
I
did
can whip
you
it out for
cancel
you
it?
now. No. She called
Or
her.
did
She left a
she?
voicemail, and I have the recording of that voicemail. And we were consulting with our advocate to find out, what do we need to bring in, this, that, and
Mhm.
the other thing. 2 business days later, she filed all the court stuff.
Right, but why did that keep you from going to the office and keeping... It shouldn't have...
Now you've
ended
brought
that
me to
appointment.
court. So, usually in a criminal court anyways, when someone brings you to court, you don't talk to the other party,
Oh.
without your lawyer present.
And that's not at all the way... We have to keep working. And
Mhm.
I explained this to you,
The
I think, on the phone, that we were doing things concurrently. So Marion was talking to you and setting up these appointments, June 5th, there was a legal consult. So we were getting ready to go to court if we needed to, if we didn't get the information that we needed. And we probably set ourselves a 60-day timeline to check in again. Okay, are we getting what we need?
Mhm,
And if
absolutely.
not, then all right, I guess we don't want to do this, but let's go to court and see if that helps speed up the process.
Did you provide those documents, Kelly?
Yes,
Like,
in my responding materials and my answer and plan of care, I also swore an affidavit with exhibits A through O, doctor's note, immunization records, activity receipts, all kinds of stuff. And I have it here. It was a 105-page
Okay,
affidavit.
but when was that submitted?
It would have been the week after the first appearance, so mid-August.
So why did the judge on August 6th still order doctor's letters?
Because I trusted my lawyer to file my papers, and what ended up happening is my lawyer didn't show up and didn't file my papers.
Okay,
But I have
because there's
email.
no record that we got those in August. Right? We did not
I
get
filed it the
anything.
very next week.
We didn't get anything until December
Hang on.
4th from your nurse practitioner and
August
your
13th,
doctor.
I swore it on the file. August 13th. I swore all of this on the file.
And who served us with that?
I did. Me and my husband, we came here, we served at reception, and we
Mhm.
swore it all in.
And there's doctor's notes in
There's
there?
all kinds of stuff in there. Yeah, doctor's notes, OT reports, IBI
From how
reports.
long ago?
All current. This is immunization records, printed July 20th.
So this isn't matching with what I've read in the file. Do you mind if I just take a look at that?
look. I mean, it should
Okay.
still be on all the...
I'm sorry for my silence, but this
Yeah, it's
my
not
door
yours,
ends.
no.
But I'm interested. I think it's
Mhm.
a worthy discussion.
It's basically everything I had offered in that letter from June 19th. So I was thinking, that's how I give it to you. Okay, I file it and serve it.
And then what, then you had Mary Beth for the August 7th home visit.
Yeah.
So Marion was gone by that time. So this is another crack probably where, I don't know if Marion saw this. Okay, I'm still looking for, do I look at the, okay, there's that.
Here's, I did a table of contents, if that helps guide you a little. Do you want to see it, or if you're looking for something specific? All my emails, assessments.
Okay, so I wonder, just bear with me.
Sure.
So this may explain why the focus on August 6th or after August 6th, between August 6th and December 4th was on a doctor.
Because I had given doctor's documentation?
Well, I haven't seen a doctor yet. I've seen a Bachelor of Science, a speech language pathologist, and the Hotel du Child Development Center assessor.
For Matthew?
Yeah,
So,
who's a psychologist.
Okay, this one is OT and physio. Haven't seen the psychologist yet.
And like I said, all the immunization records are in there too.
Yeah.
All the up-to-date, done in a timely manner for all their lives immunization records are in there.
So my guess, without being able to
I know
talk
we
to the
wanted to
manager,
speak with
was a
Dr. Penny.
doctor.
I think Dr. Penny was your GP, is that right?
Yeah.
Mhm.
I know there was a question, and I hope you don't take this the wrong way, but there was a question just about wanting to be sure about the kids' health, like their health and well-being, and nutrition, because the school, one of the I think people at the school had identified like just a question about good nutrition in the home. So I know for me as the intake manager at the time, I definitely was saying to Leslie, like, I want to talk to the GP. Yeah, I want to get some information directly from the GP. And I feel like it was Dr. Penny.
Yeah.
Okay.
But
Okay.
in July, according to the case notes, in July, which is the month you guys brought this to court, according to the child's needs strength assessment, it indicated that the children's medical needs were being met in July. Which would be another question I have, what changed between July and December?
Yeah.
Ultimately, you guys withdrew for that doctor's note, but the month you brought it to court, it's indicated in the case notes that the children's medical needs were being met. So what changed?
Yeah, I can't answer that, Kelly. And it may be, are you looking at a checkbox on the risk assessment?
No,
Yeah,
I think she's probably
Child strength needs assessment.
the family and what the ongoing worker would do within that first month, right? The FCSN,
Right. Okay.
is what I think. The family and child strength and
Mhm.
needs, right?
Yeah.
The FCSN informs, and I can't answer that either because we don't do that at intake. At intake,
Yeah,
it's focused very much on fact finding
It was
and
done
then verifying.
in July.
Yeah, which makes sense that it would be the first month ongoing piece.
Okay. So it's possible that we still wanted a medical doctor, a current one, to confirm that the needs were being met. This stuff, thank you for showing me this. I mean, that does show that you took some steps in August to give us information. I really appreciate you doing that.
You gave us this package. You gave us this package.
Yes, I served it
copy
here.
it. Okay, a copy of it. Okay.
Yeah, you guys should have it.
But you didn't find that in the file, Kim?
I didn't find it documented. I didn't open up every single
In open
legal
text,
package in open text, which is probably where that would have been buried. So let me just look at. So when Mary Beth visited you on August 7th, she still brought a lot of consents for you to sign.
Mhm.
So I guess we were still wanting to contact them ourselves at that point, and just ensure that is our best practice, and it is written in a standard, in some form, that we should not accept sort of third-party information. We need to go right to the source of the information.
Well, interviewing
So
collaterals is an identified piece of investigations for sure.
So that is our preferred practice, to get it right from the person's mouth rather than either through you or somebody else who might, like a school, who might give us information about what a doctor has told them or a counselor has told them. So that's why we were still, if we had this in July, we were still wanting to talk directly to the people, to your support people, and why Mary Beth was going after consents.
Okay.
And So this helps explain though why by December we had narrowed the issues down to the a doctor letter, and then you provided the nurse practitioner and CHIO, and that allowed us to withdraw from court, right? Yeah.
Okay.
I don't know if that helps at all.
Yeah, it does.
Okay.
It does. Another question I have is on the June 19th letter from Marion Ratzinger, she offers alternative dispute resolution, which on the 10th she offered that. On the 19th, in my email, I accept that. But I never actually got it.
I saw in the file, I see those things and it didn't go anywhere. So
Well, actually, in the case notes, it says that ADR wasn't even considered, but she offered it. Why would she offer it if it wasn't even considered? And then ultimately, she didn't give it to me. So, I mean, I was trying to avoid court.
I didn't read that in a case note, so I must have missed that. Do you know what date of case note that's in, that it wasn't considered? Or is it there's a tick box in one of the documents where you have to tick whether it was considered or not, but
just that, I mean,
anyway.
I never actually, I accepted
Yes,
ADR.
thank you. That might have really helped.
What would have helped is if you gave me what you offered. That would have helped even more.
Fair enough. It's in the investigation summary that we did as no. So I can appreciate, because so at the time,
Leslie didn't.
Leslie didn't.
That's
Leslie
right.
and I didn't, because I think we felt at the time we were beyond that, because we weren't getting at that point much cooperation from you. Again, very early on.
I let you guys come in on the first.
But again, like just with
everything.
but with in terms of a fulsome cooperation and to complete the investigation.
But if I'm cooperating in a fulsome way, why would I need ADR?
Oh, sometimes we can cooperate, but we can still disagree on some pretty central issues.
Yeah.
Like being able to see your kids privately.
Or sign consents.
So
why didn't Leslie consider ADR then?
Oh, well, and I mean, Leslie was gone before we had the opportunity to do that. So Marion did, which is great. And again, it could have really helped. I'm not sure where the request went. I know during that time period, we had a wait list because the funding had been used up. So it may have gotten lost in that, or quite honestly, it might have gotten lost in the worker change between Marion and Mary Beth. Did you talk about ADR with Mary Beth? Or just kind of drop it?
It was in court, I mean.
But even when we're in court, sometimes a judge will, and like the different parties will agree to take it sort of off the court track, or just do a long adjournment to allow ADR to occur.
It would have been great if she offered it.
Yeah.
So that's something we could have done better. We could have pursued that child mediation, child welfare mediation would have been perfect for this, because there were really two narrow issues that we could have sat around a table like this and probably worked out. I totally agree with you.
Okay. So we touched on that. So ultimately, why was the matter brought to court instead of working cooperatively with me?
Because I felt like we were at the team felt like we were at a crossroads, and again, we had kids that were vulnerable. We didn't even feel like we could complete a fulsome investigation because we didn't have collateral info. We did feel that, what we did observe in the initial at the initial contacts was concerning, and we didn't feel like we had you or well, I guess I mean, there was some indication that maybe Derek was willing to work with us voluntarily, but you weren't. Just a couple comments that he made during.
Well, I mean, through all my emails in that 60 days, I'm trying very hard to work cooperatively, and because
Getting
of
into the
workers
home, yeah.
leaving, and you're telling me this has happened, I mean.
So again, I think for us, it was, we can't sort of spend tons of time trying to, negotiate, sort of the terms here, that we need to have two plans on the table. We didn't want to necessarily go down the court road, like I said earlier, and have to go for a full supervision order. But again, knowing that we had, kids under 5, and certainly even, I think, your little one at the time was under 2. So in our, what we consider our more vulnerable population, we felt that we needed to pursue a court application to get this in front of a judge, get the records that we wanted, to make a fulsome decision. So that's why.
But I mean, ultimately, you guys withdrew. You didn't get the records you wanted. It just seems to me that
we didn't. I
didn't sign a single thing.
No, but we did. We got the letters from the nurse practitioner and the doctor, and coupled with that, we'd been in your home 4 times and seen that it was staying clean, and safe enough for the kids. So those 2 things combined together made us feel
not really court-worthy, in my opinion.
It's court. What's court-worthy? I get it. You're right, but by the end of June, when did we serve you?
Yeah.
By the end of June, it'd been 2 months, and we hadn't been in your home, and we hadn't seen your kids. That's when we get nervous and worried.
Yeah. Well, it would be nice if when you guys get nervous and worried that you maybe respond to emails or work cooperatively instead of bringing people to court.
I felt that Leslie tried to
trying.
do that. I mean, she did say, I want you guys to sign consents. I can come to the house, or you can come to the office, and it was a no.
No, it wasn't. Day 1, I said, yes, we'll do those things if you provide us with the concerns and the basis for them. Leslie never did that. And it was 41 days after requesting that we got that information.
And so,
and your request
you
was
honestly
in
did
writing,
not,
and that was in writing, because
it was verbal,
positive
but
Leslie would
recorded.
have told you verbally what the concerns were.
And I guess I'm asking you, honestly,
she told me.
You really didn't understand what the concerns were?
Yeah, I mean, they were very speculative concerns. I mean, when she first came into the house was untidy. It wasn't deplorable conditions. I mean, yeah,
I felt I did feel that I was concerned about the environment on the first, from what I could see in just the video, I did feel like the conditions were poor. I did feel like that was not just a situation where a family had a couple of days had let things slide housekeeping wise. I felt like that was a concern that had gone on for some period of time, maybe for a variety of reasons, but for me, when we've had situations like that with other families, right? And for us, what we need to be able to see is that the changes that you made, and you made some changes within a couple of days, and there were certainly, you'd identified there were, more changes that you were hoping to make, and some of them were some financial difficulties around your plumbing issue, and I'm sorry if I'm getting the facts a little bit wrong, but so fair enough. But we want to see that over a period of time, because I don't think it gets to that state.
But you could
over
have
a couple
seen
of
that
days.
if you worked cooperatively with me. I mean, and a big part of
And I guess I'd
having
say vice versa. I don't.
If you'd let us in the home, then we could have seen it.
Right, and
I
we
did
wouldn't have
let
been
you into my home.
Not till August 7th.
You let us in twice.
With a court order.
May 1st, I let her in, and then I
Sure.
requested very specific, and having it in writing is important because it gives me the opportunity to address it thoroughly. I mean, this is my kids. I'm very concerned.
I understand. Do you think Leslie had a good understanding that you wanted it in writing?
Yes, I do. And I requested on video, which I have and can show you. I requested on video. I wanted the concerns in writing and the basis for them.
And that's fair. I don't know that should stop the process, though, because, putting you know, getting letters and documentation together, etc., you know, can take time. I mean, our priority as child protection workers is the face-to-face pieces with our families, right? It's getting out to see our families. It's getting those phone calls to our collaterals. It's doing, you know, the guts of the work. And the documentation is important for sure, but it's sometimes secondary. And I'm not saying that's your issue, but that's reality. And if you have any understanding what you do with social services, you'll know that's a constant battle, right? It's a constant balance of the, I need to do my pieces of work, my direct service, and I need to balance it with my documentation. So fair enough, it shouldn't have taken 41 days. On the other side, I would suggest that you could have continued to let us into the home concurrently while you kept pushing us to get you what you needed from a documentation perspective. I guess I don't see that, you know, you had to have the letter and that way and you weren't going to cooperate at all. Like, it's almost like, I'm not doing anything more until you get me the letter. That's how I take that.
That's how it was meant.
Right. And I guess I just don't know in hindsight if that was a particularly helpful approach either. Just my perspective.
Okay, yeah, fair enough. Fair enough.
Because, and you know, the other thing is, Kelly, and what I would suggest, and again, hopefully we're not here again, right? And hopefully we're not knocking on your door again. But I would suggest to you, if you're in that scenario again and you've asked for something, call Leslie's supervisor. Because I didn't receive a call from you. And I'm not blaming. I actually think it's good when you're trying to work things out with your worker, for sure. But if you really feel like I've asked for something and I haven't gotten it and we're now going on like 7 days, 10 days type of thing, ask to speak to the workers manager.
Okay.
Because then I get it in my sort of head that, oh, you know what, this is maybe more of a priority than my worker is understanding it to be. So Leslie may well have, and I think you're right, like I'm not going to dispute, she probably did know in her mind that Kelly wanted something in writing. But again, it's like, where does that fall on the list of all the priorities that we have to manage? Whereas if you had called me after, obviously not the second day, but if some time had gone on, not 41 days, to say, I have asked for this and not getting it, then I could have lit the fire and said, Leslie, we need to prioritize this in all of you. And I could have helped her figure out a way to prioritize it. Just for future.
Yeah,
hopefully not needed.
That's a great suggestion. Thank you for that.
Yeah.
And that, honestly, that happens a fair bit. That supervisors talk with clients and help resolve some of the disagreements. That it's the most common way things get worked out, rather than coming up to me or going to CFSRB or going to court. Actually, so.
Okay. Okay. Moving on. So another problem I had was why did Marion Ratzinger continually come to hand deliver letters even after I told her to stop because we were feeling harassed?
That is another thing that we talked about. I remember as the team and really felt that, and even our legal, we were getting legal advice that we have to continue to try to engage the family. So I hear you. On the one hand, it's sort of like they've told us not to come to the home, so we shouldn't come. On the other hand, judges want to see that we're still making efforts to attend the home and engage the families.
Could have mailed it.
Yeah, but I'm saying we are wanting workers to keep trying to go to homes and engage the families
face to face.
To try to say, Kelly, I know you don't want me.
Even when they say they feel harassed.
Yeah, absolutely. Yeah. Kelly, I know you don't want me here, but it's my job to be here, and I'm hoping that we can have a conversation today, and you're going to let me in, and you say to her, Marion, go away, no way. Well, she's going to leave, and she's going to try again, at another point in time. And I hear what you're saying. You feel harassed. At the same time, if we have concerns about your kids, we've got to keep trying, right? At the end of the day, the kids that people call us about are our clients at the end of the day. And so sometimes parents tell us, you're not allowed to go to the school and interview my child. Well, then we get a referral. Well, yes, we are. Even though you don't want us to, and I get that, and I do understand that as a mom, I really do. But we still have to, and that is within our scope to do that. So we still sometimes do things that clients specifically tell us not to do. Okay. And I know that doesn't feel good. It's probably not the answer you want.
Makes sense, though.
But it's an honest answer. And I was a part of that conversation, and I remember saying to Marion, you can't let this lag. We need to try. You don't know that maybe if you go there and you have a conversation with Kelly one day, that you'll come to an understanding and she'll actually let you in and you'll have a talk. Now, I don't think that happened, but I was holding out for hope. Okay.
Okay. Next, I guess would be a question for you. Do workers get reimbursed for mileage?
Yes.
You do? Okay. Another problem I had with Marion coming by, the last time she came by, which was to serve me this, I just had a problem with her. She was trying to get my kids, who are toddlers, to let her in. I mean, is that a typical practice of your agency for workers to be asking children that they've never met to unlock the door and let them into the house?
It wouldn't. It would be. What I read in the file was her calling up and asking if the parents were home.
That's not what happened at all.
So we would not enter a home without parents welcoming us in unless we had reason to believe the kids were at risk of harm or alone and unattended. Well,
Okay.
and that would be being at risk of harm.
Yeah, my husband was.
We may talk to. I should qualify that. We may ask kids to come to the door and talk to us, and we may talk to them outside to try to ascertain their safety. But we're very cautious about entering a home without permission unless we have proper grounds.
I think it was a good lesson for my children to learn, and my husband was telling me that he had just gone to the bathroom. She wasn't there, in my husband's opinion, long enough to get to a conclusion maybe these kids are home alone. I had literally just left. I was gone maybe 5 minutes, and I pulled in, and she was trying to get the kids to unlock the door. I mean, she wasn't there really long enough, you know, to come to that kind of a conclusion. My husband was in the bathroom a couple of minutes, and he said he saw her trying to get the kids to unlock the door, and the kids almost had that door unlocked. And that's when I pulled in, and he came out shortly. He thought they were maybe my friends for a second, and then he realized who they really were. So your agency condones that?
Not the way you describe it. So what I read in the file was Marion trying to engage the kids and ascertain whether there were parents home or not. And could you have parents come to the door?
The way I phrased it,
so
the way it happened. Different. But the way I phrased it.
Okay, so I don't have an explanation for that.
Because Marion might have a different take on it.
Yeah.
Okay, and you, I guess, take workers' words over clients' words?
Not necessarily. And sometimes we have to agree on different interpretations of events.
Okay.
I mean, similar to what we've talked about in terms of you feel like Leslie threatened you, and we feel like Leslie was being open and transparent with you. That's an interpretation of what words meant.
I have most of it on video.
Yeah, it's still an interpretation of what those words on the video mean.
Well, I mean, other things in that video,
I didn't see Leslie threaten you at all. You felt like it was a threat. I understand that.
Okay. Okay, so another question I have, after the first court-ordered visit, this is coming from the case notes, it reads that, and I'll read exactly how it's written. We have a 2-week supervision order on this family, and the worker at the time, which was Mary Beth Zeman, is not yet in a position to be able to make a decision as to whether or not we should extend this. So my question is, where's the urgency in the statement that would, require bringing a family to court and then placing the children in the parents' interim care and custody?
So the way I read the file is we had to go to court to get in your home. I'm just going to bottom line it. Right? So the only way we got in the home was August 7th after a judge told you had to do that on August 6th. And that was our main goal.
But then you got into the home, and then you say, well, we have a 2-week supervision order on this family. Not sure if we should extend this. I mean, to me, if you bring something to court, you should be sure that it belongs in court. You have a police report or...
So that means means we haven't seen enough. So
At the
we
very
are
least, a
saying,
verified
I think
concern.
it said August 7th looks good, right? Isn't that note said that the house was, house like clean and acceptable. You didn't want to sign consents that day. So it was just one visit wasn't enough. How I interpret that in the file is she didn't have enough information to withdraw from court yet.
Okay, but shouldn't you have?
Or did
I mean, at this point, I've been brought to court for concerns that aren't even verified. It just seems to me stuff that should be in court is, stuff that you have actual facts about, like is a police report, bruises on the kids, stuff like that. This was completely speculative, and I don't think it should have been brought to court unless you had something.
We had the state of the home on April 29th.
Your interpretation of the home. I mean, on the video, most people have said that there was toys on the floor, crayon on the wall. I mean, there wasn't feces spread everywhere, old food on the floor. And if you watch the video, the cupboards are clean, the floors are clean.
I don't agree with you. I'm sorry.
No,
I don't. I saw the video. I realized that's not the entire house. What I saw, it was concerning. And I saw those videos that were posted on social media. And I think what I also saw was a mixed bag of comments to them, actually, where some people felt like, not a big deal, and other people's comments felt like those were not appropriate conditions of the home. So I think right there just speaks to, that's a video. It's a fact. It's in your face, right? Like, we're not talking about interpreting words. We're just looking at something, and people will see it different. You see it differently, obviously, than Leslie did, and than I did. I did feel like that was a verified neglectful environment on April 29th.
Okay. Well, I disagreed with that.
Absolutely.
Ultimately,
Absolutely.
I wanted the judge to decide.
Yeah,
absolutely.
But you guys withdrew before the judge could just make a decision like that, hold people accountable. You guys withdrew before any of that could happen.
Withdrew
your application.
Okay.
So my responding materials were never read by the judge.
So, I mean, there's nothing I can say to that other than it does tell you something when CAS withdraws from court.
Mm-hmm.
Then that tells you that we no longer have enough concern to be in court.
Okay, or
So
that maybe you didn't have enough concern in the first. This is just how I'm interpreting.
You could, yes, you could interpret it that way, maybe. I mean, Erin Lee and I are saying we disagree with that, and I think the fact that on August 6th the judge ordered a home visit might
Based on
suggest
a very misleading affidavit.
Okay, well then so it depends on how you interpret that. You're right. Yeah, so I'm sorry you didn't get your day in court, but it certainly helped us. We got to resolution and we got out of your life, which I think is what you ultimately wanted.
Yeah.
On that, can we agree?
Yeah, I think so.
And it does sound like from what I'm hearing, because at intake we're, as you know, because you've got our standards, we're 30, 60 days, and then we're passing it on if it's required. So I didn't really know what the outcome was, and then Kim had reached out to me about your call, and so it's kind of nice to hear if things have gone better for you and the kids and the family. That's good. I mean, that's ultimately what my goal was right from the get-go. It's really unfortunate that we don't agree on how that happened. And I absolutely think that we can own that there were bumps along the way in the process, and some of that has to do with a couple of those worker changes gapping there for sure. And not providing you with documentation in a timely manner is I think a fair thing for us to own.
Okay.
Like in terms of the letter that you requested.
Yeah.
So I look at every situation, Kelly, as I hope you do, as an opportunity to learn and to get better, and that's why. So I hope, we're not trying to be defensive. I just want to also be blunt, when I don't agree, like we we see the situation as it was on April 29th differently. But at the same time, I do think there were some bumps along the way.
Okay. But going to the bumps along the way, was anyone reprimanded for these bumps along the way?
Can't share that with you at all. I'm sorry.
Okay. So if a worker gets reprimanded, you can't share that
No,
at all?
It's a private matter that is not shared with anyone other than the
What if someone
worker involved and the manager.
abused by a worker? I mean, would it not be in the public's best interest, to be in the spirit of transparency, to tell people? I mean, what if there were more victims? Would the agency want to know if more people were abused by a worker, or as you said, maybe this has happened to someone else, the same bumps in the road has happened to somebody else? I mean, would not be worth looking into? Or, from a client perspective, and that kind of comes with the fact, your workers aren't registered, so they're not required to be registered, so there's no, when they get reprimanded, if it's not up for the public to know.
Right.
And I think that's really dangerous, because you can have other victims, or people that were abused in whatever way, or if it was just bumps on the road. I mean, it seems like you'd want people to know that. So if more people were affected, they could talk about it, or even have closure about whatever experience they might have had.
So our organization and the way child welfare works is there is a lot of oversight. So Erin Lee's role as a supervisor is to really be involved in key decision points of a case and approve the case recording, like look at every step of the way, which is pretty intensive compared to other social services. So that's how we monitor and evaluate and oversee our staff. Again, it's not the right thing to do to inform clients.
If a worker's been reprimanded?
No, it's not best practice, not the way we work. If we felt clients were at risk, then we would take action, and we may need to do some investigation, and that would probably be with something that was criminal as well.
Okay.
So with something that's serious, it's possible. If
a worker's criminally charged, do you tell the public?
I don't think
that.
Yeah.
Yet.
I've been here 30 years and I haven't had that happen. I can't see us doing a media release or but certainly
A criminal charge
is public, but we wouldn't broadcast it.
Not
I don't
necessarily.
think.
In cases of domestic violence, they usually keep the name of the accused to protect the victim, right? So it's not necessarily public.
Yeah, I don't think one of our staff being criminally charged would warrant. Well, I guess if the victim was a child, then that might have an order not to be made public. But yeah, that's a question I don't know the exact answer to, because I've never experienced it.
There's no policy around that?
There's certainly policy about our oversight and taking action if
there's no specific policy.
There's no specific policy saying we will inform the public
or that you won't
inform clients.
So
no, our policy would be silent on that, other than to say we have an obligation to ensure there are not other people at risk, whether they're clients.
But how would you know there are other people at risk?
Well, then we would be doing some sort of investigation or of what.
But I mean, you have victims that aren't even part of the agency anymore that have moved across the country. I mean, unless it's knowledge to the public, how would you ever know the impact that person may or may not have had?
Well,
Unless you made it public.
That's when we rely on people to come to us with their complaints and
But if they don't
Because
know
we
the
don't-
worker's
yeah,
been
but-
charged, why would they come forward?
But if something happened to them, they need to come forward.
But if it's a child, I mean, that's hard for a child to do, and a child might not even know what happened to them was wrong.
Yeah,
Mhm.
fair enough.
Okay.
Do you know of any other organizations that would publicly post
Ontario,
things like that?
the College of Social Workers and Social Service Workers
They
posts
post formal disciplines.
reprimands, and any media would.
Okay, but you're talking about a whole different layer. So, for example, if I work in a hospital, I'm required to be registered with the Ontario College of Social Workers. If I'm working as a social worker, I would be registered with the college. If I had done something that was, didn't follow procedure, or I didn't do the best job, or I fumbled something, or I didn't provide documentation, in a timely way, or whatever, my supervisor might reprimand me. But that doesn't mean that I was formally disciplined by the college, and the college doesn't know every time.
But if you violate the code of ethics,
Absolutely, right.
you'd get reprimanded.
But not every reprimand has to do with a violation of the code of
but
ethics.
unethical
Right.
ones do. And I just feel like your policy around being quiet on, if a worker was criminally charged, there's an entire college that disagrees with that. And
Well, and I didn't say we would be, I guess maybe my choice of language, I didn't say we would be quiet.
We just don't have a policy.
We don't, our
specifically.
policy is silent on it, and I said we wouldn't.
silence
broadcast
officers
it.
quiet.
What I meant was there's no written statement or direction
That says we do or
that
we don't.
that we do or we don't. That's what I mean by it's silent on it. So yeah, thank you. I didn't mean we were going to have a gag order and cover it up.
No. And in fact, I think it would be a case-by-case scenario.
Mhm.
It would depend on what the charge was, who the victim was, and what risk we
any
felt.
worker that's violated the law and been criminally charged with it, I would think that the public would have a right to know. I would think that if they violated the law, then
Right.
the law isn't a value that they have.
Right.
What kind of values are they going to have for the standards or?
So Kelly, you've had a criminal charge, right?
Mm-hmm.
So do you feel your workplace should have announced that to?
If I was
World?
working with vulnerable children, absolutely. Absolutely.
Okay.
I had to disclose my arrest to the college and give the particulars of it
Mhm.
when I registered. Absolutely. Absolutely. If you're going to be working with children and the most vulnerable children, yeah.
So, and I even see that, I see a criminal charge is different than a reprimand, right?
Okay, but we're talking
Yeah.
about criminal charges right now.
Okay. But it started because you asked about
Mhm.
reprimands and
Yeah.
whether they were made public.
Yeah.
Right, okay.
Okay, so I guess my next question is, why aren't workers registered? Why isn't it required? Why aren't they required to be registered with the Ontario College of Social Workers?
We are really struggling with that as a field, and we haven't decided yet where we're going to land in child welfare. It may come in the future. We don't know.
But if you don't know, shouldn't you err on the side of what would be in the best interest of kids? Kind of like when you guys brought me to court. You weren't sure, so you brought me to court. Sort of the same logic here. If you're not sure if you should be or not, then maybe until you figure that out, you should be registered. It would be in children's best interest, I would think.
Yeah, and I think because of the risk in the work that we do and the likelihood that people are going to be upset with some of the actions that we take to protect kids, it puts us at high risk of complaints.
Okay, but I mean, you don't trust the college's
What
processes
the
for
difficulty is
figuring that out?
the difficulty is that, well, the college can't investigate the college isn't going to make a decision on whether an abuse or a protection finding was right or wrong.
Well, no, you wouldn't
They're
bring
going-
that to the college. You would bring
Some clients
this
may bring
person
that to the
threatened to
college.
take my children away, and I've lost a lot of trust in this social worker field. That's in violation of the code of ethics. It's something I could bring to the college, or Miss Ratzinger trying to get my kids out. That's another violation of the code of ethics. And these are just examples, but you wouldn't bring decisions of being brought to court or child. You wouldn't be bringing that to the college. You'd be bringing very specific complaints about them violating that code of ethics that comes when you're registered with the college.
But they're all in the context of that investigation or that court process. So we've got court to be accountable to, and we've got CFSRB and now the child advocate. So there are a lot of judicial bodies that oversee us and hold us accountable and make sure that we are respecting clients' rights. So
unless you withdraw before the judge can see it, then there's no accountability, which is what's happened in my
I
case.
disagree with that.
Because can a judge not accept a withdrawal? Like
Of course, yeah, a judge can do whatever they want.
If we
A
did
judge
withdraw,
could have also said on August 6th, CAS, you don't know what you're talking about. You should withdraw right now. And that
but they
can
could also say
happen.
you're not
Yeah.
withdrawing because I actually am going to put an order in place.
They could have subpoenaed all those records and everything. The judge didn't do that. So, I mean, we could argue that both ways.
Yes, absolutely.
Yeah,
You can always argue things both ways. Yeah.
Okay. Okay. Another thing I had heard, I was wondering if the union for the employees here, do they protect workers from being registered with the college?
Protect workers from? I don't understand.
Well, because if you were to say, okay, now everyone working here, if you were to decide, okay, everyone has to be registered, and you were to say that, I mean, there's still employment standards, right? And they're unionized here.
Do you mean does CUPE discourage workers from being registered?
Yes.
Oh, okay.
Well, it's
don't
not our
know.
place to answer
No,
that because
no.
we're on the management
We're not
side.
in CUPE,
Yeah.
so I don't know the answer to that.
Well, but you're the management side, so you would have, I mean, if this
I
was
can
used
tell
for
you what-
bargaining purposes, I mean, if CUPE promised to protect workers from that, I would assume there'd be some sort of trade-off, and which, as management, you would know.
I'm not understanding you. Sorry. Trade-off of what?
Okay, I'll go back to what I was saying about if you suddenly decide that you're going to make workers registered, it wouldn't exactly fly. A lot of your workers aren't even eligible for registration.
Mm-hmm. So then we'd have to develop some kind of process as an organization to, I guess, probably with the college. That's part of the struggle in the field too, is how we handle people who may not be eligible, but who've worked in the field for years and years. We'd have to develop some kind of process with the college to address those people. And how I can't tell you what that would entail.
Okay, so the union has no say whatsoever as to whether or not the workers should be registered or not.
The union can always put forth a position and a recommendation. I'm not aware of any position CUPE's taken on the
one
college,
way or the other.
and it's not my place to speak about that. And I think if registration does become a requirement for child welfare workers, it's something that's going to come from the whole province, like either from the government or something that
Not something you'll take upon yourselves as an agency.
Sorry, it's what? Not?
It wouldn't be something you would take upon yourselves as
No,
a full agency.
I think we're going to see, there's a provincial sort of initiative or a provincial group that is examining this and looking at it for the province of Ontario, and we'll see what comes out provincially, either from the CAS is in Ontario, or whether the government requires something of us.
Okay. So basically, you're not going to make your workers registered unless you have to.
All I can say is right now, we do not require workers to be registered. That's the decision this organization has made.
Okay. Fair enough. I guess my next, I have a complaint about the complaint process. Bear with me here. Actually, I have several complaints about it. But
How are you doing for time, Erin Lee? I'm conscious of
Yeah.
yours, and we're getting more organizational, so
Right.
I really what
It's
time is
5
it?
to 3.
Would you mind if we let her go, or if you have more case questions, can we do those before we do the organization ones?
yeah. So
Okay.
you're good.
Okay.
Okay.
Thank you.
Okay, so it was nice to meet you. Thanks, Kelly.
Nice to meet you too.
Okay, take care.
Okay, thanks.
Okay.
I have to say your questions are really interesting and making me think.
I'm glad. So like I said, I do want to, I'm not against you guys.
I
at
feel
all.
that. I do.
I respect your agency, what you do.
Mhm.
It's a hard job. It's a really hard job. Okay, so my first complaint about the complaint process. So why can't complaints be made when a matter is before the court? Help me to understand how that's
Well,
of
so
children's
that's part of
benefit.
the law, and that, well, because the court is the complaint process.
Okay.
So it's, you've got a judge there to hold us accountable, decide who's trained and understands the law and can decide if we've done the right thing or not to protect a kid.
Okay.
Now you can, but I should also correct you there. You can complain about some process things, like whether we've responded to you on time. Whether you can complain about whether the information in your file is accurate or not.
I tried complaining too, like you said, in July when I was brought to court. I had called and was speaking to Marion Ratzinger's supervisor,
Mhm.
Lisa Muir,
Mhm.
and I tried to complain about, the timelines, and was basically told that she disagreed with me, was basically called a liar, and then she told me it was up to the judge to hold her workers accountable. I mean, okay, fine, it's
Yeah.
in court, but you're still her supervisor.
I agree with you there. We could have had some more talks there about timeliness. We would have had to separate that out from the child protection issues that were going on in court. But yeah, I think that we could have responded to those concerns better.
Okay. Okay, so according to the complaint,
Sorry, can I ask you, so you talked to Lisa when?
Lisa Muir was, I ended up talking
I've got
to her.
July 23rd, does that sound right?
That might have been when I made the complaint. I didn't actually end up talking to her, and it was the day before court, so August 5th. Was the day that our conversation actually took place.
And the one that's on video or
Yeah.
on audio? Okay. Okay. So did you, after that August 5th conversation, did you get what you were looking for in a more timely way, or at least or was it all kind of folded in with the court documents by then?
The day after that, the temporary motion kicked in, so, I mean.
So it was kind of a moot point?
Yeah.
Yeah, okay. Okay.
Okay, so the complaint pamphlet indicates that there's 2 legislated processes for complaints. The review board being one of them, and that meeting with agency staff and 1 community member. So you told me last week that I could find this legislative process in the Child and Family Services Act, but I wasn't able to find it.
It's tough, I know. Because so it's an amendment to the Act, if it's Bill 210.
Bill 210? Okay.
But just Google, have you Googled CF Child and Family Services Review Board?
Yeah.
And there's stuff about the internal complaint review panel in there.
Okay, but that's the board, not.
But well, that's the internal complaint review panel is another piece of the CFSRB. I find it confusing. It took me a while to wrap my head around this.
Okay,
so they spelled out in the CFSRB legislation, they spelled out another way that CASs could handle complaints, which is the review. Could. Well, if a client requested.
Okay, and it specifically says an independent panel.
Yeah, yes.
Because
it's not any, I mean, the whole panel isn't independent because it consists of typically like a manager who hasn't been involved in the case, again, if that's possible.
But again, okay, so internal complaints is legislated. Okay, but is that particular process of internal complaints legislated?
There is some, yes, in the CFSRB. It's probably a regulation, so I'm not...
If I go to Ottawa CAS, they'll have the same internal review process? I guess is my question.
Yes.
They'll have the panel with the independent community partners?
Yes.
Okay.
Yeah, ICRP, Internal Complaint Review Panel. And that was the whole purpose of that legislation, was so that every CAS kind of followed the same
internal
thing. Yeah, because it really confused people across Ontario, understandably. Yeah.
Okay. Okay. Okay, now I just got a few questions left. I wanted to go back to, you touched on it a bit, but how does the agency evaluate the quality of service? How do you know you're doing a good job? Or a bad job, I guess.
Yeah, so we talked about some measuring of standards.
You said, I think, compliance to standards is what you used?
Compliance is that just means following the rules. Complying means following the rules. There's like 200 and some standards, so I don't want you to think we measure all of those. Right now we're measuring 10 or so.
Can you tell me what those are?
Yep. So response times.
Okay.
Meaning how quickly we get out to see kids.
After the first initial...
When we get a call, then how quickly we see the child involved.
Okay.
And it's a private contact with the child.
Okay.
Okay, so response times, how quickly we finish an investigation.
Okay.
So that 30 days, is it complete at 30 days? Is it complete at 60 days?
Okay.
Do we have monthly face-to-face contacts with clients?
And that's from the standards?
Yes.
Okay.
So that's that ongoing protection. The standard is we see I'm gonna get the language right, families monthly or see children monthly. And in children in care, we have a regulation that they must be seen privately every 90 days. Our agency goal is every month. So we measure those things for monthly contact for all of our clients. We measure if every client gets a complaint pamphlet on first contact.
Did you know that?
Well, workers have to write it down in their file and say they gave you a complaint pamphlet. So we just audit the file.
Okay.
Complaints. We do a random sample of case notes to see if workers are entering case notes within 24 hours.
Okay, and when you do that, do you review the, like, not the entire file, but the entire file of the current concern?
No, we just do a random sample of case notes.
Okay.
You asked me what we're measuring.
Yeah,
So that's
yeah.
different than approving
Right.
files. So we can
Yeah.
talk about that next. Case notes, complaints. When we make a decision to close a file, do we close it within 30 days? We are measuring if we keep cases open beyond 2 years. Our policy is that we have a meeting to look at whether that case still needs to be open, just to critically ask ourselves the question, what are our goals on this case? What are we doing? Why is it still open on 2 years? Is there anything else we can do to be more effective?
Do you have that meeting before 2 years?
No, after the 2-year mark.
So you don't have any
But-
kind of meeting like that, like say after 1 year?
Oh, yes, we might. It's just not a rule for every single case.
Okay.
So in this, workers are expected to have those meetings on every case that's open over 2 years.
Okay.
Okay. We're almost at the end. Case notes. I think that's it. So then so those are just the measures. We do, this is the second year we have done a complete file review of a random sample of files. Last year we did intake and ongoing.
Okay.
And we did over 100 files, probably over 200 files last year.
And you reviewed like the whole file?
We develop certain questions and certain standards and certain quality items that we think that we want to look at, and usually the ones we want to improve on. So typically you end up looking at the large majority of the file to answer specific questions. So I can't say we read a file from front to back, every single word in it, but we read a good chunk of it in that process and look at the work we did and what we could have done better, and did we explain our work as well as we could have.
Okay.
As well. So this year we're doing all of our services, so intake, ongoing, adoption, foster care, and children in care. And we hope we'll be continuing that every year, maybe every 6 months. We have to see how that goes and make sure it doesn't interfere with seeing clients.
Yeah.
So that's the internal review. So then I've also explained that a supervisor plays a really critical role, and there's certain points, as you know, in the standards where a supervisor has to approve decisions.
Mm-hmm.
So that has to be written, and supervisors have to approve the file documentation. So you've probably seen that in your file disclosure, like places where you've got a line that says the supervisors approved this.
Okay.
So that's the supervisor's job, is to also on a daily basis make sure their workers are doing quality work.
Okay.
What else do we do? Well, I think I told you this before. We have complaints that give us a lot of information about how we're doing, and serious occurrences, which are reports we have to do to the ministry on more like serious things that have happened mainly to the children in care that we serve, but it may be other things as well. So we have to ask ourselves, if we have a lot of those or an unusual number of those, does that mean we could be improving our work?
What's an unusual number for this agency, for this area? What's an unusual number of serious occurrences?
Oh, I'm not good at
Ballpark?
Yeah, I know. I rolled this up for our board of directors last month. Just a sec. I had the complaints off the top of my head for you. I want to say between 20 and 30 serious occurrences a year. But you need to know what those definitions are, right? They're not. So serious occurrences are death of a client, a serious injury to a client, a disaster on the premises, a missing client, abuse of a client, restraint of a client,
All restraints?
medical admission,
Medical admission? Like to the hospital?
or yeah, that it sort of goes with the serious injury thing, but and there's an
Okay,
other
sure.
category too.
Okay, and that's just for things that don't fall into these ones?
Yeah.
Or? Okay. Okay, so so then
Unusual would be it's very rare we have a child death in our jurisdiction. So to and to have a child death that isn't sort of expected, like we've had some child deaths of babies who were born with some severe congenital difficulties who it's expected that they're going to die at some point. Those are more
causes.
yes,
Hate
yeah,
to say it like that.
yeah,
Kids, but
yeah, me too.
yeah.
So those aren't unusual, maybe about one a year, but a child death because of abuse or suicide is unusual for us.
Okay.
So that's something we review very thoroughly.
So unusual is 20 to 30.
No, usual. The usual number of serious occurrences in total is 20 to 30 per year. That's what I'm saying.
Okay. That's an upwards of 2 a month.
Mm-hmm. The majority of them are injuries, either accidental or self-inflicted.
Okay.
That's kids in care and primarily teenagers. And the other high ratio is missing kids, which is kids who run away
Okay.
and are missing for a period of days until they decide to come home or we find them.
Okay.
And they're typically teenagers.
Okay.
And you would ask me every restraint. Yeah, the ministry regulation for children's residences is that every child restraint is reported as a serious occurrence to the ministry.
Okay. Okay. Even if the child was restrained because they're hurting themselves or something like that.
They want
okay,
to
that's good.
It is good.
I think
It is.
that's
It's
good.
due diligence. It's making sure we're not
absolutely.
overusing it as a behavioral technique. Yeah.
Okay. Okay. What about stuff? I mean, I have to wonder. The intake worker on my case is gone. The second supervisor on my case is gone. So I'm wondering, is stuff like high staff turnover used for measures?
Organizational performance?
Yeah,
Measurement?
yeah, yes.
Absolutely. Yes, that is another measure that we do. So we have like an HR department that gathers those statistics and analyzes them. Yes.
Okay.
So turnover and absences, sick leave, and all those things we look at to try to look at the health of our organization.
Okay. Okay, is it typical for, my involvement was April to December, about 8 months, right? Is it typical to have 2 workers leave?
No.
Does that seem...
No, it's not typical.
So, is it fair to say that, I guess over the summer, is where that sort of falls, there was, the agency was maybe understaffed?
Yeah, again, it all depends on how you
would explain
define
bumps
that.
in the road.
Yeah, so we had some unexpected leaves of people in the summertime, and we had some we probably didn't have our full worker complement. And that means we have, like, in our plan, we have a certain number of permanent workers on our staff organizational chart, and we didn't have all those positions filled.
Okay. 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 An next question would be, how much extra money did understaffing leave in the budget?
Oh, I can't answer that off the top of my head. So that's called vacancy. Well, you can do it on purpose, and it's vacancy management. So you can decide when somebody goes on a maternity leave, I think I can manage good service without filling this position, and I need to save some money in my budget, so I'm gonna do that. That's,
okay. But you mentioned that
that's on purpose.
You had several unexpected
Sometimes you have unexpected ones, or you can't, you have problems hiring the staff that you need, and you have vacancies because of that, and you end up saving money because of those vacancies, but it wasn't like a plan that you had. It just happened.
Okay. At any rate, the understaffing would have logically left money in the budget. What does the agency do with the surplus in the budget at the end of the fiscal year? I mean, I'm on a board, I know how it works. You know, if you have money, you have to spend it before the end of the fiscal year.
Yeah, our ministry actually fixed that with a new funding formula 3 years ago. So we have something called a balanced budget fund with the ministry that our surplus, if we have a surplus, goes into, and then it can be used with the ministry's permission for other things.
So what would you guys use with it? Or what's the process for determining, if the ministry approves it, what's the process for determining how to spend it?
Well, that's our whole budgeting process and our strategic and our service plan. And I guess the other thing I should let you know is we sort of have a global or an overall budget. So we aren't confined to spending money just on one thing.
Yeah,
so the salaries,
yeah.
So it's what the ministry watches or expects from us is just that we manage the bottom line and how we spend, with whether we spend it on children in care or salaries for staff or administration or training or conferences or brand new buildings or whatever. That's our we have that flexibility, and then we have our board of directors oversees that.
Does the board then decide what happens to extra money, like where it goes? Am I hearing that right?
Again, it really depends on the level. So they oversee that, and they would be, I don't know if they always approve the budget. So yes, in a way.
The ministry always approves the budget?
No, the board of directors approves the budget. The ministry expects that we always have a balanced budget. That's what they hold us accountable to and hold our board of directors accountable to.
Okay.
So I think the organization, the senior management team and the management team decide how we manage our budget. I hesitate to say extra money because we never have extra money.
Yeah. Surplus.
There's always kids in care needs, client needs. There's always ways we can use our money.
Okay, and it's the senior management that decides where the surplus goes?
Again, we do that in consultation with managers. So, we have
as in you and the board do it in consultation?
Yes.
Okay,
yeah.
So the board and the managers kind of work together to spend the surplus?
Yeah, that's a simple way of putting it.
Okay, I like simple.
Okay.
Okay, I think that's it for my questions. I have maybe some suggestions.
Sure.
Has the board of directors, the agency, ever considered maybe doing a client feedback survey?
Oh, thank you. Yes, I meant that is on our strategic plan.
Okay.
We're not doing it yet, but we absolutely need to do client
I think that would be
surveys.
great.
Yes.
I think, because rather than go through the, I mean, and it's
Can I, you know what I
daunting.
need? I need to take your name down and remember it for when we want to develop that.
Okay.
Like, so would you work with us on that?
Yeah, yeah.
Okay.
Absolutely. Absolutely. No, I think that would be great. And we were talking before, obviously some people might not be very happy with having their children apprehended. And so they're going to make, so in a case of that, I mean, I was just thinking, you know, even people who have their children apprehended, I mean, there's still a potential that they were abused by the worker or not treated fairly by the worker. But just because they're disgruntled doesn't mean...
You're right, absolutely. Doesn't mean they weren't treated improperly.
Exactly.
Yes.
Yes. Another thing that's kind of going around a lot is to have workers wearing body cameras. A lot of police
like
departments.
police do.
Yeah.
Oh, isn't it funny? I just react to that. But well, again, and it's privacy things too. Do you want your kids videoed?
If it would ensure that
Accountability is what you're going for.
yes, then yes, absolutely. I think in the long run, and it would save a lot of this conflicting information from happening. I mean, we wouldn't have to take someone's word against someone else's. We just watch the video. I think in the long run, it could save the agency a lot of money. It'd be comfortable at first, but you'd get over it, and you'd maybe have some training around it. And, I kind of help people.
Yeah, I mean, it's the first time I've heard that brought up as a potential tool in our field. So interesting.
Ultimate accountability.
It's expensive, so whether we'd have the province willing to fund that for us, or we'd all have to find it ourselves. Whew. Anyway,
Maybe there's a
cool
surplus in the
suggestion.
budget that could be invested in something like that. I just think it would save a lot of money. It would save unnecessary court adjournments.
Well, I don't know. Did the video help in your situation? We've still got different interpretations of what was there.
Yes, but if to be fair, right? That video is of me. You can't read my body language or anything like that. But if Leslie had been wearing a body camera, then there wouldn't be any interpretation at all. Because what prompted me to grab my camera was her. She was just being very condescending, and it got to a point like, whoa, but like they just basically barged into my home. And one thing and this is what prompted me to grab my camera, is she said she didn't need a warrant to take my children. That prompted me to grab my camera, and I think maybe my video would have had maybe a bit more weight to it had that statement been captured. I mean, I felt that was bad. I can't prove that she said that, though, so I haven't included it in any of my
Well, and
comments.
it's true. She does. If any of our workers feel children are at serious and imminent risk of harm, and that if they take the time, the 2 to 4 hours, 2 to 6 hours it might take to get a warrant, that those kids will remain at risk. We do have the power to
It's
apprehend.
true, but was it necessary to tell me
Yeah,
that
I
to
get
gain
that.
entry into my house?
Yeah, it's.
I felt
Yeah.
like she used that to gain entry and to get her way, basically. So
And was that her intent?
she wanted into the house. I mean,
Did you ask for a warrant? How did a warrant come up? Or did you ask if she had a warrant to come in?
No, I was not going to let them in.
Mhm.
And then my husband came to the door after hearing it, and he kind of let them in. When a cop comes, okay, the cop was there for her protection, but when a cop's at your door, you're not gonna think, you sort of enter a state of shock, right? Kind of like when you get pulled over for speeding. You can't find your license. It's because your brain loses a little bit of oxygen, so you go into a bit of a state of shock. That's what I think happened with us. It was like,
And you'd had previous experiences with the police.
Yeah, so I feel had that cop not been there, I wouldn't have entered in that panicky kind of stage, and I think the whole thing would have gone way different.
Oh, I'm actually really glad to hear that, because it just means there is a solution here.
Or police. Alan Hogan was quoted in the paper last September. He said that you guys don't bring police unless you don't see any other way in. In my case, they never even tried any other way in. So I thought that it just, is Alan Hogan, did he lie to the newspapers, or, is what happened to me not supposed to happen?
Well, so there's a difference between, Alan was talking about situations where we have to get into a house to see kids. So he said, tell me his words again.
What did I have the article here?
We only bring police if we have to.
Yeah,
right?
If we don't see any other way in.
So in your situation, there was a judgment made that because there was a chance of needing to do a joint police CAS investigation, because there might have been something of a sexual abuse nature about the call, that's the second reason, or an additional reason, the police were there.
Well, the police had concluded after interviewing, and this is according to the case notes, the police concluded after interviewing the children that no offenses had occurred.
Yes.
To me, with that logic, then police involvement should have ended there. But it didn't. They came to the house, and then 2 days later, they came to the house again.
Well, and 2 days later was more to help keep the peace and to help.
The whole reason there wasn't any peace was because you're bringing police officers into my house.
Totally
right? My kids are.
If we had to do it over again, we would have left the police.
Okay. That makes me feel better.
Good. Thank you. Well, and you've got it on file now, and I should actually make sure that that is up front on your file.
I would appreciate it, because ultimately the reason I made this complaint was because the way things are was that this exact same thing could happen again. And I don't want that to happen, but I've got some good suggestions from this to talk to the supervisor early on.
Yes, that would have made a huge difference too, I think. Yeah.
And I think you guys have gotten some suggestions from me.
Yes, thank you. I appreciate that.
I look forward to the client feedback survey. I think that will...
Would you call me back if I don't get back to you?
Sure.
Like,
can I
let's say,
you?
Yes, email me 3 months. Okay. In 3 months.
3 months. Sure.
So that is by May 2nd, March, April, May. Yeah. Because even if we may not be anywhere close to starting that project, but what I can do is at least sit you down with somebody to write down your ideas, so that when we are creating a client survey, I've got your ideas captured. Like, I want to get this while this is fresh for you. So if I haven't done that by May 2nd, please email me and I'll get it done.
Okay. Because I would like to see, because it's another problem I have. It's not really something I can formally complain about, but just the language around the entire child protection field. I look at the eligibility spectrum, for example, And so when it's rating things, we have severe or extreme. What is it? Extremely severe.
Extremely severe, yes,
right?
and severe and moderately severe.
And then minimally severe.
Yeah.
Like I almost came in here joking, saying, "Well, I'm minimally happy with my services."
That's good.
So when you're doing the client feedback, really pay attention to the language you're using. And so, like I said, you don't have someone, minimally happy or like that. You're just a suggestion in the language. Or I guess that's it for my questions.
Okay.
I don't have any more suggestions.
All right. Thank you. I have actually really enjoyed this. I really appreciate your feedback, and yeah, I look forward to doing more stuff together with you.
Okay.
What do you want to do next?
What do I want to do
you
next?
want to look at the ICRP? Do you want to do any other processes?
I think I'm gonna go home. Can I let you know on that?
Oh, absolutely.
I think
Yes.
I'm gonna go over my notes and see